Hi everyone, Dave Sugden of Evidence at Trial. We're talking about the Donald Trump trial now pending in New York. In prior videos, we've talked about the danger of open-ended questions with a witness like Donald Trump. And we've talked about the unusual conduct of Judge Engoron during Mr. Trump's testimony. In this video, we're going to talk about the power of impeaching materials when examining a witness. To set the stage, the case pending in New York deals with the allegation that Donald Trump and his co-defendants inflated the value of his assets and properties in order to get favorable interest rates from lenders and favorable policies from insurers. The judge in the case has granted summary judgment on the merits of the case, and the trial now is about determining damages. The state called the former president as a witness in their case in chief, and the objective of the examination was to show the extent to which Donald Trump misrepresented the values and characterization of his various properties. And one of those properties is a building in New York known as 40 Wall Street. Now, Donald Trump had been interviewed in 2015 by Forbes magazine, wherein Donald Trump told the magazine that the building was 78 stories tall. Meanwhile, the Trump website and marketing materials described the building as 72 stories tall. And in documents filed with the city, the Trump organization represented the building as being just 63 stories tall. The examining attorney had both the magazine article and an audio recording of the interview with him when he was questioning Donald Trump. And the attorney chronicles the varying representations but does not ask him a single thing about them. Instead, he asks whether Mr. Trump knew whether or not in September 2015, 40 Wall Street would throw off $50 million by the end of the year. Beyond the question being unclear, he's asking the former president whether or not a future prediction he made in September would be true by the end of the year. Donald Trump provides a meandering answer about how he doesn't respect Forbes magazine and how he deals with them very quickly. But the portion of the examination is important because it provides a clear example of a lost opportunity with the Trump examination. When you have a witness who has said clearly different things on different occasions, and you have a recording of the statement, you can pull off a very simple and effective cross-examination with simple and short leading questions. You could begin this topic by simply asking, Mr. Trump, how tall is 40 Wall Street? You can ask a non-leading question here because the answer doesn't matter. Whatever he says, you have two examples where he has said something different. Even if he says, I don't recall, which is itself hard to believe because he prides himself on being an expert on his properties, you can then ask a series of short leading questions. Well, Mr. Trump, you told Forbes magazine it was 78 stories tall. True? If he denies it or does not recall, you go straight to the audio clip. If he says it's 78 stories tall, you say, well, Mr. Trump, your own marketing materials say it's 72 stories tall. Isn't that true? Again, if he deviates, you introduce the pages from the website. And once you've gotten some commitment or evidence in that he has represented the building as being over 70 stories tall, you then say, and yet, when filing documents with the city, you told the city that it was a mere 63 stories tall. Isn't that true? Ignoring this information and simply asking about the accuracy of a future prediction really missed the mark. It is much more difficult to show a witness was being dishonest when they make a future prediction. There's just too much wiggle room for the witness. The witness can say anything along the lines of, well, when I said this prediction about the future, I believed it to be true. But these conditions that I did not anticipate, they happened, or whatever. These questions, they land a much softer blow than confronting and exposing a witness who has said two different things to two different audiences. It was a missed opportunity. When you have these types of opportunities, you have to expose the witness. Folks, I hope this was helpful. If it was, please like, subscribe, hit the notification button. If you want a topic covered, leave a comment. If you want to do a really deep dive on how to apply the rules of evidence or these evidentiary concepts during trial, check out our online course page at evidenceattrial.com. Thanks for watching.